はい、こんにちは。本日はですね、中国の実用新案についてですね、中国の専門家の方と中国人の弁護士の人とですね、話をしていきたいと思います。なぜ、中国の、実用新案なんですかというふうに、思う方もいらっしゃるかもしれませんけれども、実用新案っていうのは、日本で耳にしたことはありますか？まあ、あの、我々みたいな専門家はもちろん、聞いたりする機会はあると思うんですけれども、特許とか著作権、っていうのは、皆さん、たまには、聞いたことがあるかなっていうのが、あると思うんですけど、例えば、1000倍特許ですとか、違法コピーダメみたいな、著作権の、映画とか、いろんなところで見ますよね。日常の生活の中でも、そういった特許とか著作権っていうのは、たまに耳にしたりすると思うんですけど、実用新案っていうと、もうほとんど聞かないんじゃないかなというふうには思うんです。で、実は、日本の実用新案の申請の、ケース、実用新案っていう制度があってですね、そこに出願する人の件数っていうのは、日本では年々減少していってしまってるんですね。2019年の日本人による実用新案の申請っていうのは、3693件なんですね。これって多いの少ないのっていうふうに、思う方多いと思うんですが、例えば特許、実用新案とは違う特許っていう制度があるんですけど、それだと、年間30万件以上はあるんですよ。ですから特許に比較したらですね、約100分の1ぐらいしか、実用新案っていうのは出されていないという、現状なんですね。で、しかも、年々下がり続けてますよね、これね。2015年にはですね、5213件あったんですけど、2014年にはもう4000件台に落ち込んでしまってですね、2018年にはなんと、3000件台になってしまっています。でもこれなんででしょうね。日本は、実用新案って結構古くからあって、明治時代はですね、日本の人が、知的財産権を申請する、レベルがそんなに高くなくて、明治時代ですね、外国からの、製品が入ってきて、それの改良をするような、そういうアイデアばっかりだったんですね。改良発明って我々呼んでるんですけれども、そのためですね、当時進んでいたヨーロッパ、具体的にはドイツの実用新案制度っていうのを見習ってですね、明治38年に日本で実用新案法というのが制定されたのが始まりなんですね。で、その後、日本は、1970年代、80年代、ですね、経済発展を迎えて、もう世界でナンバーワンの今、特許保有国になったんですね。そして、実用新案っていうのが、もう特許はこれだけ皆さん、日本人の人たち申請してるから、制度的な意義をですね、何のために実用新案っていうのがあるのっていうことを、高めるために、平成5年にですね、今までは、実用新案っていうのは特許と、同じように、しっかり審査官が、審査をしていたんですけれども、これをもう審査しないという制度に日本は変更したんです。法律改正してなんですけれどもね。申請したら、そうなると、審査しないので、いきなりと登録になっちゃうんですね。で、これがですね、権利が本当に有効なの無効になっちゃうんじゃないのっていうような、権利の有効性がですね、不安定に、なってしまったんですね。で、誰も審査しませんからね。もう、申請したら、 書式的なチェックはしたりするんですけど、その後すぐ登録になっちゃうんですよね。特に日本の状況を考えると、日本の特許庁っていうのは、特許の新規性、進歩性っていうような判断基準、大きなもの2つあるんですけど、登録になるためですね。そのうち進歩性の判断、つまりどれだけこれは難しいのっていうような、そういった難しさを要求する判断っていうのが、もう世界でもトップレベルに厳しいんですね。最も厳しい国の一つなんです。で、実用新案の権利はですね、そんな日本の特許庁の審査官がですね、無審査のやつを後々登録になってから、何か問題あってからですね、審査されても、結局その時潰れちゃうんじゃないのっていう、心配が、あったんですよね。で、日本人はですね、そんな不安定な権利を取るぐらいだったらお金を出してですね、今まで通り特許出すよと、そういう反応が今の実用新案件数の数につながってるんではないかと思います。で、一方で、同じように実用新案制度っていうのを、ドイツの他にもですね、アジアの国結構採用してるんですけど、中国なんですけれども、2019年の中国人による実用新案の申請というのは、225万9765件なんですね。200万。っていう。日本なんかもう3693件ですから、これももう400% 以上なんですよね。中国は、人口が多いとはいえ、もうすごい違いですよね。実は実用新案、中国の実用新案は特許と同じぐらい人気なんですよね。費用も、特許に比べると、中国の特許に比べると半分ぐらいで申請できて、同じように無審査なんですけれども、中国の審査レベルというのは、日本の審査レベルに比べるとそんな高くないので、権利がそう簡単に、進歩性に関して言うと、潰れないんですよね。で、日本人の申請する人、中国に申請しましょうっていう人たちは、あまりこういった事実を知らないので、中国へなんかアイデアを申請するときには、もう必ずと言っていいほど特許を出すんです。中国特許を出すんですね。これは日本の実用新案の悪いイメージ、不安定っていうイメージが、非常に強くてですね、外国でもそうなんじゃないのっていうふうに日本人は考えがちですよね。日本でこうなんだから海外でもそうでしょうみたいな。で、今日はですね、そういったイメージを払拭できればというのが今日の目標なんですね。そのために今日は中国の専門家をお呼びしています。紹介しましょう。
Hi everyone, my name is Alan. I'm an IP counsel under China IP jurisdiction, and our firm is Japan IP law. Founded in 1988, our firm has gradually developed from a small-size patent legal service provider into a full-service IP law firm specializing in broader fields of IP filing, prosecution, and litigation. Over the span of 30 years, the firm has expanded to a total of 10 offices in Beijing, Changsha, and Guangdong, staffed with a team of hundreds of professionals covering all technical backgrounds. And as I said, and I am an IP counsel in the International Department of Japan. I serve as a coordinator, a mediator, and licensed to help domestic and overseas clients with any kinds of IP matters in China. And I will take today's chance to share some info about the Chinese utility model application. Hope all of you will find today's speech helpful at some level. So let's begin. As you can see in this first slide of my PowerPoint, my whole speech will follow this outline. What I will share today are patent types in China and their flows from application to the extinction of the rights, the typical timeline for utility model, the advantages and disadvantages, the same-day application for an invention patent and a utility model, and the technical evaluation report. Let's start with the first part. There are 3 different protection methods in China patent law. Each of them has a different duration. One law covers everything in China, while there are different laws in Japan. I know that. Regarding the inventions, the duration is 20 years. The object of protection is the invention of products and method. Both formality examination and substantive examination are conducted before registration. Depending on the inventions, it will take 2 to 3 years to get granted. Next, regarding the utility model, the protection duration is 10 years. The object of protection is the structure of things. Only formality examination is conducted. Generally, it will take about 6 to 10 months for the registration. And regarding the design, the duration will be 15 years. The object of protection is product design. The method of judgment is the design of the shape or the pattern or both. Generally, it will take about 4 to 6 months for the registration. As you can see, utility model and design don't require substantive examination in China, so the registration process will be much faster than that of invention patent. Next line is about the flow from filing the application of a utility model to the extinction of the rights. After filing an application for a utility model, a formality examination will be conducted for registration, but without a substantive one. During the examination, the invention step is not taken into consideration. After the decision of the registration, the contents of the utility model will be open to the public, so everyone can see it. The applicant, after that, shall pay the registration fee. The utility model rights will be extinguished 10 years after the application. This survival period cannot be extended at all. Here we come to the advantages and disadvantages. The advantages, first of all, as there is no substantive examination, you can get your rights very quickly. It's also important to know the cost of acquiring utility model is lower than invention patent. I will explain more about this in the next slide. Cons has 2 sides, of course. The disadvantage is that it has a limited range of protection. The utility model covers only the invention of products, but not the invention of methods. And since it doesn't require a substantive examination, the rights tend to be relatively unstable when comparing to the invention patent. And of course, I will dig deeper into this point later. So I just said the low cost is an advantage of the utility model. Let's compare the actual difference between invention, the utility model, and the design. These 3 tables showed the cost respectively. The cost of intellectual property is divided into 3 parts here in China. As you can see here, the official fee, the attorney fee, and of course, the third part, the translation fee from foreign language to Chinese. In addition to the application fee, the stable includes the cost of claiming priority, which is necessary when applying to China based on the original application in Japan or in other countries. The administrative fee paid to the China Patent Office also varies depending on the length of the application. As you can see in the tables, additional charge of claims or page will be required if situation happen. As a typical example, let's think about a case when the claims is within 10 items and the specification includes drawing doesn't exceed 30 pages. So there will be no additional charge in these two parts. In the average case of an invention patent, assuming that the number of characters to be translated is 15,000 and the total cost will be $3,314. On the other hand, in the case of a utility model, assuming that the number of characters to be translated is 5,000, the total will be 1,500, about 1,500. Therefore, utility model require less than half the cost of inventional patent. And that's why I said at the beginning, it's more cost effective. In this slide, you can see an approach that is being actively used in China, filing an invention patent and a utility model patent on the same day. In other words, you will prepare two identical documents. One is for the patent application and the other one is for utility model application. One thing to keep in mind is that if you have a prior application in a foreign country, for example, in Japan, you need to go through the Paris Convention to work on this approach. Same-day application cannot be made from the International Patent Convention, aka PCT method. Let's see the method of the same-day application and how it benefits you. First, in China, many intend to monopolize their intellectual property rights as soon as possible. However, in the case of a patent, they have to wait a minimum of 2 to 5 years for the registration. Taking even 4 to 5 years is also common if the case is rather complicated. The brand periods of intellectual property rights hardly match with the ever-increasing business speed nowadays. Considering today's quick business, competitors possibly take control of the market during the brand period. The Chinese market has many competitors who are always watching each other's movements. Therefore, this approach is frequently used in China when protection is needed as soon as possible. Second, when the utility model in China is registered, you can retain it as a backup of the invention under examination. After all, in China, not all the patent applications end in success. At last, if the patent has been registered as well, the applicants can hold both the utility model and the patent. However, in that case, the protection scope of these two applications should be different, aka the claim set should be different. This is prevent duplicate registration, which is also stipulated by the law in other Asian countries, for example, Japan. Such amendments to the claim set are not so difficult for local Chinese patent attorney. We can also capable to do that.
I had mentioned that the patent right of the utility model might not be stable as there is no substantive examination when talking about the disadvantages of a utility model in the previous slide. So on this page, we will talk about the technical evaluation report. The purpose of the technical evaluation report is to confirm whether the registration of utility model and designs which were without examination are correct. If there is no way to confirm like this, no one knows whether the utility model registered without examination is a valid one or not. First, we need to know the examination body is the Chinese Patent Office, aka CNIPA. The patent who can request the Chinese Patent Office for the preparation of the technical evaluation report is the patentee or any of the interested party. Licensee or licensor if you need example of what are interested parties.
So let me explain the contents of the technical evaluation report with specific documents. The evaluation's contents of the report are mainly divided into three. The part enclosed in red is the validated evaluation, invalidated evaluation, which the rights cannot be maintained, or partial invalidated evaluation. The partial invalidated evaluations will list the maintenance is permitted or forbidden in each claim. In the case the report is positive, the utility model rights have no problem in its validated. In other words, you can force other companies to stop infringing the content. In case the report is negative, the utility model will be invalidated. Then the utility model rights cannot be utilized at all. In the shown documents, all 5 claims items of the utility model rights got invalidated evaluations. At last, in case the partial invalidated evaluation is shown, you can only force other company to stop infringing the claim that has no problem in its validated instead of the whole utility model. Since multiple rights or claims can be stayed in one utility model's application, some claims may be validated, while some others may not. In China, before filing the utility model applications, your Chinese attorney will go through the whole filing document, so they will have a big picture of the estimated result if there is an evaluation in the future, which leads to a positive expectation to the patent owner. Therefore, utility model seems to be rarely used in Japan, but the number of applications in China is about the same as that for invention patent. So how's the technical evaluation report used? The report has 3 rows. First, the judgment in the technical evaluation report is treated by the court and the patent office as evidence for the judgment and the trials in the proceeding for utility model infringement. Second, it can be used to apply for deletion of posting on the internet, which also known as filing the complaint on sales platform, Alibaba in China or Yahoo sales platform in Japan, for example. Third, it can be used to apply for custom registration. For example, if you dispute a utility model infringement in court, you will need to request a technical evaluation report. Through the report, a substantive trial is conducted to decide whether to maintain the rights or not.